Did you know you can suffer a life-altering injury, yet still end up with a small settlement? It happens more often than you think. My name is Steve Sweat. I've been a California personal injury attorney for over 30 years, and I've seen countless people fall into common traps that destroy the value of their cases, often within the first week of their accident. That's why I'm creating this video. I'm going to walk you through 5 types of injuries that typically result in the highest settlements, from the most severe to the ones insurance companies love to downplay. For each one, I'll expose the defense tactics used to diminish your claim, and more importantly, reveal the leverage moves you can use to protect yourself. So stick with me, because there's one injury that should lead to a massive settlement but often doesn't, all because of a single document they sign far too quickly. So let's start with the first category, which I would term as kind of the life-changing or catastrophic injuries and also wrongful death. The life-changing tier are the cases where settlements can reach 6, 7, even 8 figures. Why? Because the damages aren't just about pain, they're about lifetime care, lost earning potential, and a permanent change in your quality of life. This category would include things like paralysis, severe traumatic brain injuries, major burns, blindness, amputation. On paper, these cases are massive, but the biggest hurdle is often the insurance policy limits. If the at-fault party has minimal coverage, their insurance can't pay what isn't there. This is where many people get blindsided, settling for the policy limits without realizing there could be more. So let's talk about what the defense playbook is in these cases. Insurance companies have a go-to strategy here. First, they'll tell you there's not enough coverage, hoping you'll stop asking questions. Next, they'll shift the blame, claiming that you were speeding, not paying attention, or could have avoided the accident. And finally, they'll dig into your medical history and point out any pre-existing condition, old back pain, a prior concussion, ADHD, and they'll confuse the narrative with that. So your leverage moves and how you fight back is you want to build your case as if you're explaining it to a jury of 12 strangers. We lock down the timeline, the cause of the injury, and the before and after story. And we use the eggshell plaintiff rule, which states that if a pre-existing condition was made worse by the accident, the defense is still on the hook. The key is proving the change in your condition. Most importantly, we hunt for every possible source of coverage: employer liability, vehicle owner liability, umbrella policies, and multiple defendants. This is where we separate ourselves from the settlement mills that just take the first offer and move on. We find every pocket to maximize your recovery. Let's talk about the second category, kind of what I call the hardware fracture cases. Fractures requiring surgeries are serious. They can involve the femur, tibia, ankle that require surgery to install plates, screws, and rods. Adjusters might argue about soft tissue injuries, but an operative report and post-op restrictions change the conversation. So these cases often settle in the 6-figure plus range, but it depends on the extent of the surgery, the length of your rehabilitation, and the time you miss from work. And again, the insurance coverage is ultimately a ceiling. The defense playbook on these cases, they love to play the low impact argument. They'll point out minimal damage to your vehicle and claim the impact couldn't have caused such a severe fracture. They'll also pounce on any gaps in your treatment. You miss physical therapy or delay a follow-up, they'll argue you must not be injured. So your leverage moves here are imaging, the operative report, the surgeon's notes, and physical therapy records that document your functional limitations. Don't just say it hurts. Tell your doctor, I can't stand long enough to cook. I can't drive for more than 10 minutes. That's the type of language that moves money. We also fight back against blame shifting by meticulously proving liability with photos, witness statements, and accident reconstruction. And we negotiate hard to reduce any liens on your settlement from hospitals or health insurance, ensuring more of the money ends up in your pocket. Let's talk about a third tier here, the kind of invisible but expensive tier: spine, shoulder, and knee injuries. This next category is frustrating because the pain is very real, but insurance companies often treat it like it's all in your head. Let's start with the spine. Herniated discs, injections, and fusion surgeries can have a wide range of values. But once you have consistent radiating symptoms like pain, numbness, or weakness down your arm or leg, the value of your case can climb quickly, especially if surgery is required. The defense playbook on these cases is to basically jump on anything that says degenerative changes. They'll claim your MRI shows normal wear and tear for your age, not an injury from the accident. They'll pair this with any gaps in your medical care to paint you as an unreliable witness. So what are your leverage moves on this case? Your leverage is a clean, consistent timeline of medical care. get checked out as soon as possible after your accident, and follow your doctor's treatment plan. Map your symptoms in a way your doctors can use, focusing on how they affect your daily functions. This also applies to rotator cuff, labrum, meniscus, or ACL tears. Even if you have prior wear and tear, the eggshell plaintiff rule applies. We prove the before and after by documenting your work tasks, gym routines, and home chores to show how the injury has impacted your life. Now let's talk about the Prop 213 trap. Crucial warning about whiplash and other soft tissue injuries. While these are real injuries, insurers often undervalue them. And this is where the Prop 213 trap comes in. If you were uninsured at the time of the accident, unfortunately, California law may prevent you from recovering any pain and suffering damages, and it limits you to only economic losses. People often find this out after they've already given a recorded statement or signed documents. Don't let that be you. So here's the bottom line. A strong settlement is a combination of medical proof, liability proof, and leverage. If you're missing one of these, the value of your case can collapse. So here's your 3-step protection plan. 1, get checked out and follow up. Create a clean, unbroken timeline of medical treatment. 2, document your daily limits. Keep a simple log of how the injury affects your daily life. Take photos, save work notes, and document everything you can no longer do. 3, very important, don't sign anything. Never sign a release or give a recorded statement without speaking to an attorney first. A release ends your case forever. So if you need help, call me. You'll speak directly with a lawyer, not a case manager with our office, and we'll map out a real strategy for your case. I hope you find that information helpful, and if you want to continue to educate yourself on your legal rights after a personal injury claim, make sure to subscribe to our channel. If you want our help on any case, 866-966-5240, or visit us at our website, victimslawyer.com.